In an earlier case, Nixon against Fitzgerald, decided in 1982, that case had already held that a former president was immune from being sued civilly for acts at what was called the outer perimeter of his official duties that he performed while in office. That opinion, in turn, was based on precedent going back to Justice Robert Jackson's concurring opinion in Youngstown, Cheaton II versus Sawyer, which I think is still considered the authoritative description on the reach of presidential authority, and a discussion of the executive vesting clause in Marbury versus Madison to the effect that a president's official acts are not subject to examination in the courts. I believe the court's ruling here was narrow, consistent with precedent and constitutional principles, and that the three categories of presidential conduct that the court discussed in its immunity analysis are themselves anticipated in Justice Robert Jackson's opinion, beginning with acts at the court of presidents of constitutional power, such as the power to pardon, conduct foreign relations, and other acts, such as speaking in certain settings and circumstances that are presumptively immune, and acts that are clearly private, which are not. The ruling here was also modest in the sense that the court sensibly remanded the case to lower courts for them to consider in the first instance, in the normal course, how to distinguish what might be official acts from those that are not, and to determine whether even some official act can be the subject of criminal prosecution, if such a prosecution would not impair the functioning of the executive branch. The policy rationale for the immunity recognized in Nixon against Fitzgerald and the current case is the ability of the presidency to function independently and with vigor.